You are on Crazy Karen HOA. The plow ridge was her excuse and my problem. You are about to learn why I do not take excuses. Patricia screamed that my snowblower threw snow toward a car and she was escalating to towing and fines, unless I stopped. I had been clearing my driveway for maybe 10 minutes when she appeared at the curb, pointing at a Honda Civic parked 2 houses down, yelling that I damaged it with ice chunks. The wind was gusting hard enough to send the discharge plume sideways, but she acted like I aimed a cannon at her friend's paint job. She pulled out her phone, started recording, and told me the tow truck was already on standby if I did not apologize and pay for an inspection right now. I live in Allen, Texas, in a subdivision called Maple Ridge that treats winter storms like acts of war. We are part of the Maple Ridge HOA Incorporated, and Patricia Phillips is the neighborhood watch liaison, which means she walks around looking for violations and treating residents like suspects. I work as an auto body shop estimator, so I know how damage works, how claims get filed, and how people try to inflate minor dings into big payouts. The car she pointed at did not have a scratch. There was some slush on the hood and a light dusting of snow on the windshield, but no dents, no chips, nothing that would justify a tow threat or a fine. I turned off the snowblower and pulled out my phone. I told her I was recording too, and I asked her to show me the damage. She refused to walk over to the car. She said she had photos from earlier and that was enough. I asked to see the photos. She said she would present them at the hearing. I asked what hearing. She said the emergency snow enforcement hearing scheduled for tonight at 6, and if I missed it, the fines would double and a lien would be filed automatically. I looked at my driveway. Half of it was still buried. The walkway to my front door was a sheet of ice. My health has been fragile, and sleep disruption is making it worse, and the last thing I needed was to spend my evening in a freezing community center arguing about phantom car damage. But Patricia was not bluffing about the hearing. She pulled a printed notice from her coat pocket, folded it twice, and handed it to me like a summons. The notice had no date, no signature, just a block of text claiming I violated winter maintenance standards and endangered property. It said I owed $250 immediately, or the amount would triple by Friday. I asked her who authorized the fine. She said the board voted on emergency powers during the last storm and she was executing those powers. I asked when the vote happened. She said it was in the minutes. I asked where the minutes were posted. She said the website. I checked the website later, and there was nothing. The last update was from October, before the first freeze. I did not mention that to her yet, because I had a court date already scheduled for an unrelated traffic citation, and I could not miss another day of work, and I needed to stay calm and document everything without tipping my hand. Patricia told me I had 2 options. Option 1, I could pay the fine now, agree to stop using the snowblower, and clear my driveway by hand going forward. Option 2, I could fight it and rack up fees until the lien went to collections. She said it in a flat voice like she was reading a script, and then she smiled and added her favorite line. You think this is petty? I think this is my purpose. I had heard that phrase before, back in November when she cited me for leaving a portable space heater running in my garage while I worked on a project. She claimed it was a fire code issue even though the heater was UL listed, and I was standing right next to it. That citation disappeared after I sent an email to the management company with photos of my setup and a copy of the manufacturer's specs, but Patricia never apologized. She just moved on to the next target. I told her I would see her at the hearing. She said good, and then she walked to the Civic, took more photos of the hood, and waved at me like she had just won something. I finished clearing my driveway in silence. The wind kept drifting snow back onto the walkway, and every time I cleared a section, a fresh layer would settle within minutes. It felt like shoveling water. By the time I finished, my arms were sore, and my breath was coming out in harsh clouds. I went inside, took a shower, and started pulling together my evidence. I work in auto body, so documentation is muscle memory for me. I keep a folder on my phone with photos of every interaction, every notice, every fine threat. I also have a security camera mounted over my garage that records in high definition with timestamps. I pulled the footage from that morning and watched it 3 times. The video showed me starting the snowblower at 7:42, clearing the driveway in smooth passes, and the discharge plume blowing away from the street because of the wind direction. The Civic was not even visible in the frame until 8:05, when Patricia walked into the shot and stood next to it. At 8:06, she held up her phone and took a photo of the hood. At 8:07, she walked toward my driveway and started yelling. The timeline was perfect. She staged the whole thing. I saved 3 copies of the video. One on my phone, one on a USB drive, and one uploaded to a cloud folder with a timestamp receipt. I printed stills showing Patricia approaching the car, taking the photo, and walking toward me. I also printed the notice she handed me and highlighted the lack of a signature or board seal. Then I called my neighbor Greg, who lives 2 doors down and has a doorbell camera that faces the street. Greg is retired military, keeps to himself, but he has always been fair. I asked him if his camera caught anything that morning. He said he would check and call me back. While I waited, I went through the HOA covenant documents I had saved when I bought the house. There was a section on winter maintenance that required driveways and walkways to be cleared within 24 hours of snowfall. But it said nothing about snowblower discharge, nothing about fines for incidental spray, and nothing about emergency powers or expedited hearings. The rules were vague enough to be useless, but they also did not support what Patricia claimed. I made notes in the margins and printed a clean copy to bring to the hearing. Greg called back 20 minutes later. He said his camera caught Patricia walking up and down the street 3 times between 7:30 and 8, looking at cars and taking notes. He said she stopped at the Civic twice, once before I started the snowblower and once after. He offered to send me the footage. I told him I would pick it up in person because I wanted a backup that could not be deleted remotely. I drove over, copied the file onto my USB drive, and thanked him. He told me Patricia had been hassling other people too, mostly about snow piles blocking sightlines or ice patches near mailboxes. He said the board gave her a title but no real authority, and she was using it to settle personal scores. I asked him if he would be willing to speak at the hearing. He said he would think about it, but he did not want to get dragged into a long fight. I understood. Patricia has a reputation for retaliation. If you cross her, she finds a reason to cite you next week for something unrelated. She operates like someone who studied the rules just enough to weaponize them without technically breaking them. The hearing was scheduled for 6 at the community center, which is a low brick building near the subdivision entrance, with a meeting room that smells like old carpet and burnt coffee. I arrived 15 minutes early and found Patricia already there, sitting at a folding table with a 3-ring binder open in front of her. She had printed a full packet of photos, maybe 20 pages, all showing cars with snow on them, driveways half cleared, and close-ups of icy patches. None of the photos had timestamps, none of them showed my property specifically. She saw me walk in and smiled. "You think this is petty? I think this is my purpose," she said again, tapping the binder. I brought receipts. I asked if I could see the receipts. She closed the binder and said I would see them during my turn to speak. I sat down in the back row and waited. 3 board members showed up. The president was a guy named Dennis who owned a landscaping company and barely looked up from his phone. The treasurer was a woman named Marianne, who seemed annoyed to be there. The secretary was an older man named Paul, who kept checking his watch. Patricia stood and opened the meeting by reading a prepared statement about winter safety and the importance of proactive enforcement. She said the neighborhood had experienced multiple complaints about snow discharge, ice hazards, and blocked sight lines, and the board had granted her authority to issue citations and schedule hearings as needed. I raised my hand and asked when the board voted on that authority. Dennis looked up from his phone and said it was part of the November meeting. I asked if there were minutes. Marianne said the minutes were delayed because the secretary was out sick. I looked at Paul. He shrugged. I asked if the vote was recorded anywhere. Dennis said it was verbal and unanimous. I asked if verbal votes were allowed under the bylaws. He said they were allowed in emergencies. Patricia stood again and said we were wasting time. She said she had evidence of my violation, and she wanted to present it. Dennis nodded. She opened the binder and pulled out 4 photos. The first showed the Civic with a light dusting of snow on the hood. The second showed tire tracks in the slush near the curb. The third showed my snowblower sitting in my driveway, engine off. The fourth showed a close-up of snow spray on the side of the car. None of the photos had timestamps. None of them showed me operating the snowblower. None of them proved causation. I stood and said I had video evidence that contradicted her timeline. Patricia interrupted and said video was not admissible because it was not submitted 24 hours in advance. I asked where that rule was written. She said it was in the hearing procedures. I asked to see the hearing procedures. She said they were internal. Dennis told us both to sit down. I sat and pulled out my phone. I opened the video and held it up so the board could see the screen. I narrated the footage, pointing out the timestamps, the wind direction, and the fact that Patricia did not approach the car until after I finished clearing my driveway. I pointed out that she took photos of the car before I started the snowblower, and again after, which suggested she was setting up a comparison shot. I also mentioned that the car had no visible damage, and the snow on the hood was consistent with natural accumulation, not high-velocity spray. Patricia stood again and said I was lying. She said the video was edited. I asked her to prove it. She said she did not need to prove it because she was a sworn liaison, and her testimony was presumed accurate. I asked who swore her in. Dennis said the board did. I asked when. He said it was part of the same November meeting. If you are enjoying this story, hit the like button and subscribe for more HOA drama where the paper trail always wins. Marianne leaned forward and said she wanted to see the full video file. I handed her my phone. She watched it twice, then passed it to Paul. Paul watched it once and handed it back. Dennis did not ask to see it. He said the video was interesting but not conclusive, and the board was inclined to uphold the fine unless I could provide additional witnesses. I said I had a witness. I pulled out my phone and called Greg. He did not answer. I left a message and told the board I would submit his doorbell footage within 24 hours. Patricia laughed and said doorbell footage was not admissible under the same rule. I asked her to cite the rule number. She said it was in the handbook. I asked for a copy of the handbook. She said it was only distributed to liaisons. Dennis said he had heard enough. He said the board would take the matter under advisement and issue a decision within 5 business days. I asked if I could submit additional evidence during that time. He said I could, but it would not change the presumption in favor of the liaison. I asked what presumption. He said liaisons were appointed to act in good faith, and their reports were considered reliable unless proven false by clear and convincing evidence. I asked if video with timestamps counted as clear and convincing. He said it was up to the board. I asked if the board had a legal standard for clear and convincing. He said they used common sense. I asked if common sense included ignoring video evidence. Marianne cut in and said I was being argumentative, and if I kept it up, they would add a conduct violation to the fine. I shut up and sat down. Patricia stood and asked the board to increase the fine to $500 because I had wasted everyone's time and shown disrespect. Dennis said he would consider it. The meeting ended. I walked out and sat in my car for 10 minutes, watching my breath fog the windshield. I did not play my hand yet, and she thought that meant I had none. I drove home and spent the next 2 hours drafting a formal records complaint. I had been holding onto a trump card, something I recorded during the November incident when Patricia came to my garage about the space heater. She did not know I had my phone propped on a shelf, recording the whole conversation. In that recording, she admitted she did not actually see the heater running. She said a neighbor reported it, but when I asked which neighbor, she said she could not disclose that. Then she said she did not need a witness because her job was to investigate potential violations, not prove them. She said if I had a problem with that, I could take it up with the board, but they always sided with her because she kept detailed notes and they did not have time to second-guess her. That recording was my insurance policy. I did not mention it at the hearing because I wanted to see how far she would push. Now I knew. She was willing to lie about video evidence, fabricate timelines, and weaponize procedures that did not exist. I was ready to deploy the recording, but I needed to do it strategically. If I just sent it to the board, Dennis would find a way to bury it. If I went to the management company, they would forward it to the board and Patricia would get a heads up. I needed a state procedure complaint that forced the HOA to respond, something that created a paper trail outside their control. I researched Texas property code and found a statute that allows homeowners to file complaints with the state attorney general if an HOA violates open meeting laws or fails to provide access to records. The complaint process required me to document the specific violations, submit evidence, and request a formal review. If the AG found merit, they could issue penalties, force the HOA to provide the records, and even invalidate decisions made without proper procedure. I filled out the complaint form and attached 3 exhibits. Exhibit A was the video from my driveway showing Patricia staging the photos. Exhibit B was Greg's doorbell footage showing her walking the street and taking notes before I started the snowblower. Exhibit C was the November recording where she admitted she did not need proof to issue citations. I wrote a cover letter explaining the pattern of retaliation, the lack of board minutes, and the fabricated hearing procedures. I printed 3 copies, mailed one to the AG, kept one from my records, and handed one to a process server with instructions to deliver it to the HOA registered agent. The next morning, I woke up to find an envelope taped to my front door. It was a new citation, this time for failing to remove ice from my walkway within 12 hours of accumulation. The fine was $300. The citation was dated 2 days earlier, which meant it was backdated to create the appearance of a pattern. I took a photo of the envelope, checked my security camera footage, and confirmed that no one had delivered it 2 days ago. Patricia must have printed it overnight and taped it to my door while I was asleep. I called the management company and asked to speak to someone about the escalating fines. The receptionist put me on hold for 15 minutes, then transferred me to a voicemail. I left a message explaining the situation and asking for a review. No one called back. That afternoon, I got a text from Greg. He said Patricia had been by his house asking questions about his doorbell camera. He said she wanted to know if it was recording on the morning of the Snowblower incident, and when he said yes, she asked if he would be willing to delete the footage because it might contain private information about other residents. Greg told her no. She said she would file a complaint with the board about his camera placement. He said he did not care, but he wanted me to know she was circling back. I texted him a thank you and told him I had filed a state complaint and things were about to get loud. He said he appreciated the warning and he would keep his camera running. The next escalation came on Friday. I got a certified letter from the HOA attorney, a guy named Richard Fallon, who worked out of a strip mall office in Plano. The letter said the board had reviewed my case and determined that I owed $850 in fines and fees, broken down as follows: $250 for the original snowblower discharge violation, $300 for the ice accumulation violation, $200 for administrative processing fees, $100 for a newly invented winter enforcement surcharge that supposedly covered the cost of emergency hearings and liaison overtime. The letter also said that if I did not pay within 10 days, the HOA would file a lien against my property and begin collections proceedings. It included a sentence that made my stomach drop. The lien would include all outstanding fines plus legal fees, which the attorney estimated at $2,500 so far. I read the letter 3 times. There was no breakdown of the legal fees. There was no invoice, no timesheet, nothing that explained how the attorney racked up $2,500 for sending a single letter. It was a bluff, designed to scare me into paying. But the lien threat was real. In Texas, HOAs can file liens for unpaid fines, and if the lien is not satisfied, they can eventually foreclose. The process takes months and requires a court order, but the threat alone is enough to wreck your credit and make it impossible to sell or refinance. I called the attorney's office and asked to speak to Fallon. The receptionist said he was in court. I asked when he would be available. She said he would call me back within 2 business days. I asked if I could schedule a meeting. She said meetings required a retainer. I asked how much. She said $1,500. I told her I would think about it and hung up. I was not going to pay a retainer to a guy who was billing the HOA for imaginary work. Instead, I called a friend who works as a paralegal and asked if she knew anyone who handled HOA disputes. She gave me the name of an attorney named Laura Reyes, who had a reputation for taking on bad boards. I called Laura's office, explained the situation, and asked if she would review my complaint and the lien threat. She said she could do a consultation for $200, and if she took the case, the fee would apply to her retainer. I booked an appointment for Monday morning. Over the weekend, I kept my head down and avoided Patricia. I cleared my driveway and walkway every morning, took photos with timestamps, and uploaded everything to my cloud folder. I also installed a second security camera on my front porch aimed at the street so I could catch anyone approaching my property. On Sunday afternoon, I was shoveling the walkway when a tow truck pulled up to the curb. The driver was a guy in his 50s wearing a stained jacket and a baseball cap. He got out, walked over, and asked if I was the homeowner. I said yes. He said he had a work order to tow my car for unpaid HOA fines. I asked to see the work order. He handed me a printed sheet with my address and a note that said vehicle subject to impoundment per HOA Covenant Section 12.4. I told him I had not received any notice about impoundment. He said the notice was sent by certified mail. I told him I received a lien threat, not an impoundment notice. He shrugged and said he was just following the work order. I asked who issued the work order. He said the HOA. I asked which person. He said he did not have a name, just a phone number. I pulled out my phone and showed him the video of Patricia staging the car photos. I showed him the timeline, the timestamps, and the fact that the fine was based on fabricated evidence. I told him the HOA was retaliating because I filed a state complaint, and if he hooked my car, he would be part of a legal mess. He watched the video, looked at the work order, and said he was not getting involved. He got back in the tow truck and drove away. I took a photo of his license plate and the company name on the side of the truck. I called Laura Reyes and left a voicemail describing the tow attempt. She called back 10 minutes later and said the impoundment threat was illegal. She said HOAs in Texas can file liens, but they cannot authorize towing without a court order, and even then only under specific conditions like blocking access or abandonment. She said the work order was likely fabricated, and if the tow company came back, I should call the police and report it as attempted theft. She also said the lien threat was on shaky ground because the fines were not properly assessed. She agreed to take my case and said her retainer was $3,000, but she would start work immediately and bill against it. I agreed. I wired her the retainer and sent her all my documentation, the videos, the photos, the notices, the attorney letter, the work order, the AG complaint, and the recordings. She called me back that evening and said she had reviewed everything and she was confident we could force a settlement. She said the HOA was operating without proper procedures, Patricia was acting outside her authority, and the attorney was billing for ghost work. She said the first step was to file a motion to block the lien and request a hearing on the fines. She said she would also send a demand letter to the board requiring them to produce the meeting minutes, the vote authorizing Patricia's powers, and an itemized invoice for the legal fees. I asked her how long the process would take. She said it depended on how fast the board responded, but she expected them to fold once they realized we had the recordings and the AG complaint. She said most bad HOAs do not want to go to trial because discovery would expose their entire operation. Monday morning, I met with Laura in her office. She was mid-40s, sharp and moved fast. She handed me a draft of the demand letter and asked me to review it. The letter was brutal. It accused the board of violating open meeting laws, failing to maintain records, authorizing illegal enforcement actions, and allowing a liaison to operate as a rogue agent. It demanded that the board rescind all fines, remove Patricia from her position, and pay my legal fees. It gave them 10 days to respond or face a lawsuit. I asked if the letter would make things worse. Laura said it might, but the goal was to force them to negotiate. She said if they ignored the letter, we would file a declaratory judgment action in district court and request an injunction blocking the lien. She said the judge would likely order the HOA to produce the records, and once the records came out, we would have enough ammunition to win on summary judgment. She filed the demand letter that afternoon. I went home and waited. The board responded 2 days later with a letter from their attorney saying the demand was baseless and the HOA stood by its enforcement actions. The letter also said the board had reviewed my complaint and determined that I was a vexatious litigant and any further filings would be met with sanctions. Laura called me and said the response was predictable. She said we would file the lawsuit on Monday and request an expedited hearing. She also said the board was making a mistake by digging in, because the recordings and the AG complaint gave us leverage they could not counter. That Friday, things got weird. I woke up to find bright orange traffic cones placed across my driveway exit, blocking my car. The cones had no markings, no HOA logo, nothing to indicate who placed them. I moved the cones to the curb and drove to work. When I got home, the cones were back. I moved them again and set up my front porch camera to record the driveway. At 2 in the morning, my phone buzzed with a motion alert. I checked the camera feed and saw Patricia walking up my driveway with the cones. She placed them in front of my car, stepped back, took a photo with her phone, and walked away. I saved the video and sent it to Laura with a note that said we now had evidence of trespassing and obstruction. Laura filed an emergency motion for a temporary restraining order on Monday morning. The motion included the video of Patricia placing the cones, the video of her staging the car photos, the recordings of her admitting she did not need proof, and the tow truck work order. She requested a hearing within 72 hours and asked the judge to order Patricia to stay at least 100 feet from my property. The hearing was set for Wednesday at 9. Laura told me to dress business casual and bring printed copies of everything. She said the judge would likely ask Patricia to explain herself, and if she could not, we would get the restraining order and the board would panic. Wednesday morning, I arrived at the courthouse 30 minutes early. Laura met me in the lobby and walked me through what to expect. She said the hearing would be short, maybe 20 minutes, and the judge would focus on whether Patricia posed an immediate threat. She said the standard was low, and the videos were more than enough. Patricia showed up 10 minutes late with the HOA attorney, Richard Fallon. Fallon was younger than I expected, maybe 35, wearing a cheap suit and carrying a leather folder. He did not make eye contact. Patricia looked calm, almost smug, like she had a plan. The judge was a woman named Martinez, who had a reputation for not tolerating nonsense. She called the case, asked Laura to present her motion, and watched the videos on a laptop Laura brought. The judge asked Patricia if she placed the cones. Patricia said yes, but only to protect neighborhood safety because my car was parked in a way that blocked sightlines. The judge asked if she notified me before placing the cones. Patricia said no, because it was an emergency. The judge asked if she had authority to declare emergencies. Patricia said yes, as neighborhood watch liaison. The judge asked Fallon if the HOA bylaws gave liaisons that authority. Fallon said he would need to check. The judge said she would wait. Fallon opened his folder, flipped through some papers, and said he did not have the bylaws with him. The judge asked why not. He said he did not anticipate needing them. The judge said this was a hearing about HOA authority, and he should have anticipated exactly that. The judge granted the restraining order and told Patricia to stay away from my property. She also ordered the HOA to produce the meeting minutes, the liaison authorization vote, and an itemized invoice for all legal fees within 14 days. She set a follow-up hearing for 2 weeks out and said if the documents were not produced, she would consider sanctions. Patricia and Fallon walked out without speaking. Laura and I stayed in the courtroom for a few minutes while she made notes. She said the hearing went better than expected, and the production order would force the board to either comply or admit they did not have the documents. She said most HOAs fold at this stage because they cannot produce records that do not exist. We walked out to the parking lot, and I saw Patricia standing next to a sedan, talking on her phone. She saw me, ended the call, and walked over. She stopped about 10 feet away and said I was making a mistake. She said the board had deep pockets, and I would run out of money before they did. She said I could end this now by paying the fines and signing a settlement that included a gag order. I told her I was not interested. She said I would be. Then she walked to her car and drove away. Over the next 10 days, the board did not produce the documents. Instead, Fallon filed a motion asking for an extension because the records were stored off-site and retrieving them would take time. Laura opposed the motion and pointed out that HOAs are required by law to maintain accessible records. The judge denied the extension and said if the documents were not produced by the deadline, she would issue sanctions and possibly refer the matter to the Attorney General. 2 days before the deadline, I got a call from Dennis, the board president. He said he wanted to talk off the record. I told him everything I said was on the record because I was documenting the case. He sighed and said the board was willing to settle. He said they would rescind the fines, pay my legal fees, and issue a written apology if I agreed to drop the lawsuit and the AG complaint. I asked what would happen to Patricia. He said that was an internal matter. I told him I wanted her removed from the liaison position and a no-contact directive in writing. He said he would bring it to the board. Laura advised me to get the settlement terms in writing before agreeing to anything. She said oral promises were worthless and the board would try to backtrack once I dropped the lawsuit. I told Dennis I needed a written offer within 48 hours or the deal was off. He agreed. The written offer arrived the next day. It included everything I asked for, full refund of any fees I paid, payment of my legal fees up to $5,000, removal of Patricia from the liaison role, a no-contact directive, and penalties for retaliatory winter enforcement actions. The settlement also included a clause requiring the board to adopt formal hearing procedures and post meeting minutes within 30 days of each meeting. In exchange, I would dismiss the lawsuit and withdraw the AG complaint. Laura reviewed the offer and said it was better than she expected. She said the board was scared of the production order and the recordings. She advised me to accept. I signed the settlement and sent it back. The board ratified it at an emergency meeting 2 days later. Patricia found out about the settlement when the board sent her a termination letter. According to Greg, who heard about it from another neighbor, Patricia showed up at Dennis's house and screamed at him on his front lawn until his wife called the police. The police gave her a warning for disturbing the peace and told her to leave. A week later, I was clearing my driveway after a light snow when I saw Greg walking over. He said Patricia had been by his house again, this time asking if he would testify against me in a defamation case. He said he told her no and asked her to leave. She said she was filing a lawsuit against me, the board, and the management company for conspiracy to violate her civil rights. Greg said she had a folder full of documents and she was convinced she had a case. I called Laura and told her about the threat. She said Patricia could file whatever she wanted, but a defamation case required proof of false statements and actual damages, neither of which she had. Laura said if Patricia did file, we would countersue for malicious prosecution and abuse of process. She said Patricia was spiraling, and the board would likely distance themselves from her to avoid liability. I never heard about the lawsuit. Either Patricia did not file, or her attorney talked her out of it. What I did hear was that the management company terminated their contract with Maple Ridge HOA 3 months later, because the board was unmanageable. The new management company brought in a professional property manager who cleaned house, rewrote the enforcement procedures, and required all liaisons to go through training and background checks. The funniest part of the whole saga happened during a windstorm in late February. I was sitting in my living room when I heard a commotion outside. I looked out the window and saw Patricia standing on the sidewalk, chasing loose papers that were blowing down the street. It was her printed packet from the hearing, the one with all the staged photos and fabricated timelines. The wind had ripped it out of her hands and scattered it across 3 lawns. She was running back and forth, trying to grab the pages before they blew into the storm drain. A couple on a porch across the street was watching like it was a show, drinking coffee and laughing. I grabbed my phone and recorded 30 seconds of her scrambling in the slush, clutching pages to her chest, looking like she had just lost a court case in real time. I did not post it anywhere. I just saved it as a reminder that karma does not always need my help. The settlement money came through in March. The HOA cut me a check for $5,200, which covered my legal fees and the original fines I had refused to pay. Laura sent me a final invoice showing she billed $4,800, and I told her to keep the difference as a tip. She laughed and said I was her favorite client that year. I stayed in the house for another 1.5 years before selling and moving closer to work. The new owners were a young couple who asked me about the neighborhood during the walkthrough. I told them it was quiet now, but they should read the HOA bylaws carefully and keep records of everything. They asked why. I said I had a story, but it would take an hour. They said they had time. I gave them the short version and showed them the settlement letter. They thanked me and said they would keep an eye out. I still drive through Maple Ridge sometimes when I am in the area. The streets look the same, the snowbanks still pile up in the same spots, and the HOA sign at the entrance still has the same cheap font. But I do not see Patricia anymore. Greg told me she moved out 6 months after the settlement, sold her house at a loss, and left town without saying goodbye to anyone. He said the new neighbors were normal people who waved when you drove by and did not measure your grass with a ruler. The last time I talked to Laura, she told me the Maple Ridge case was one of her easiest wins because the evidence was overwhelming and the board had no defense. She said most HOA disputes are not that clean, but when they are, they end fast. She also said she uses my case as a teaching example in her presentations because it shows how documentation, patience, and a good attorney can turn a nightmare into a settlement. I learned a lot from that fight. I learned that HOAs operate on fear and paperwork, and if you take away the fear by calling their bluff, the paperwork collapses. I learned that recordings are worth more than testimony, timestamps are worth more than claims, and a state procedure complaint can force accountability better than a lawsuit. I learned that Karens like Patricia thrive in systems where no one pushes back, and the moment someone does, the system eats them alive. Most importantly, I learned that you do not have to fight every battle. But when you pick one, you fight it smart. You document everything, you follow the rules they claim to follow, and you make them prove their case. If they cannot, you win. If they try to escalate, you escalate harder. And if they threaten you with towing, fines, or liens, you smile, pull out your evidence, and show them exactly why that was a bad idea. I will see you in the next story.